Good afternoon and welcome to Bradford and Barthel's Wednesday webinar. We hope you are all having a great week. Today's webinar is Trial Time, Part 4, presented by Don Barthel. We presented Part 1 of this webinar topic in November, Part 2 in January, and Part 3 in February. If you missed any of those events, the videos are posted on our website for viewing anytime. We do hope you enjoy the presentation. And with that, I'm going to go ahead and hand it over to Don. Thank you for joining us today.
Well, happy Wednesday, everybody. We are exactly halfway to the weekend, so keep it up. We're going to talk today about getting evidence in or keeping evidence out of trial time. And there's a lot of potential problems in terms of doing exactly that. Let's say the applicant submits the illegible reports, or the employer's reports are found to be insubstantial, and as a result, the judge doesn't have enough evidence to make a ruling at all. At that point, there's an option: develop the record, or cut off the find against the parties. If there was a failure to present sufficient evidence by MSD, they've got a duty to develop records. It's not a lifeline. The judge has a duty to develop, but don't rely on that to save you, and we'll go over that, the specifics of that. There is a specific duty to disclose evidence, and that is greater than the general duty to develop the record. So if the judge is going to lean in one direction or the other, it's going to be towards enforcing you to conduct and complete your duty to disclose evidence at the time of the MSD. The WCJ may not leave undeveloped matters requiring further evidence, and has the authority to order parties to obtain supplemental medical reports. However, before the medical records can be augmented, the judge must establish that the existing medical file is deficient and the decision cannot be made on the existing record. However, the judge cannot exercise his or her duty to develop the record if it would unfairly reward a party who, through their own negligence, failed to meet their burdens. So obviously there's a tension here in terms of the duty to develop the record versus not saving parties who, through their own negligence, don't have sufficient evidence to win the day. There's a little fact pattern. At MSD, it was declared that they were ready to proceed to trial. The problem with applicant's QME was identified by the defense, and I believe by the judge here, and the applicant said, well, I'll get a supplemental later. And the judge, hearing that, said, well, I'll leave open discovery post-expedited, and this was over the employer's objection. Subsequently, in the FNA, the judge awarded the applicant benefits based on that supplemental, the supplemental that was only obtained and allowed into evidence because the judge allowed discovery to remain open. The DCA reversed. Why did they do that? Here, there was no attempt to justify the failure to obtain a supplemental report from the doctor. The defense objected to the original report and made it known before the settlement conference that it was inadequate. Nevertheless, the applicant proceeded to the settlement conference, declaring under penalty of perjury that the discovery was complete and that she was ready to proceed. Accordingly, admission of the supplemental report exceeded the bounds of discretion allowed to the WCJ in these sessions, or in these situations. So there is clearly a great deal of discovery given to the judge, and we're going to see further evidence of that later in this presentation, but it's not boundless. A little fact pattern: there was evidence found to be inadmissible, and the applicant said, wait a minute, my attorney was incompetent and screwed it all up. The holding was the desire to save the applicant from the applicant's attorney's incompetence is not good cause for further development. In this case, the defense was going to win it, and the applicant's counsel's E&O policy was going to receive a phone call. Best laid plans. What if you're making a tactical decision not to list evidence at the MSD? You want to use it as a surprise, and that blows up in your face somehow. The answer is going to be tough luck. In one case, it was held that the employee was stopped from appealing whether the records were properly excluded because they purposely excluded them. They made a strategic mistake. So when you're dealing with sub rosa and you have some rosa that you believe will impeach the applicant, you face the question, do I reveal it at MSC time, or do I hold off and wait for them to make misrepresentations and then introduce the sub rosa at the time of trial? There's a balance here. I've gone both ways. I've succeeded both ways thus far. I'll keep my fingers crossed for future decisions, but it is a strategic decision, and if the judge rules against you in that type of situation, you probably got a loser. More about that later. When you want to reopen discovery, how about changing counsel? I've seen this oftentimes where the judge has allowed, when a new attorney has come into the picture, particularly an applicant's attorney at MSC, the judge will take the matter off calendar to allow applicant's counsel to get up to speed. When that happens, I think the fault lies with the defense. The defense should be objecting to same, and there's case law directly on point. The Oliveras case, the fact that applicant changed attorneys is not a valid reason to develop the record. Another little fact pattern, applicant filed a DOR at MSC, wanted to amend to include psyche. Now, what does the DOR say? DOR says the discovery is all done. At the time of the DOR, the applicant actually knew they had evidence of a potential psyche, but nevertheless declared in the DOR under penalty of perjury, discovery was complete. It was held that the employer was substantially prejudiced by the judge's order to take off calendar, plainly because the applicant failed to show due diligence. And due diligence is a term of art that is sort of like reasonable. It's a full employment act for attorneys because we're always arguing exactly what reasonable and what due diligence really means. No party presents substantial evidence whatsoever in the entire case. Well, normally it's the applicant that needs to go forward with the burden of demonstrating that benefits are that they've entitled to benefits. So if there's no substantial evidence on anything, you would think the employer would automatically win. Unfortunately, we're in the workers' compensation system, and that's not necessarily the case. The WCAB is in a situation likely to develop the record if there are material deficiencies in specific records or reports, and the doctor hasn't reviewed all the relevant medical reports, or the medical file is not clear, it requires clarifying supplemental, or finally, and probably most significantly, there's a material change of facts post-MSC, such as the applicant has gotten worse. There is a danger, the WCAB will likely develop the record if, for example, there was a denied AOE, COE, an independent contractor defense, and the matter was apparently bifurcated. They went to trial only on the independent contractor defense, which the defense lost. Of course, during that process, it was found that the employee was unable to attain a medical legal process until it was ruled that it was an employee. At that point, it was held that, of course, that the applicant gets to continue to develop the record. What if the judge says the report is unclear or murky and therefore I cannot rely on it? Nope, that's not sufficient to order the development. The party of the record, the party who's relying on that unclear or murky report should have obtained a supplemental or taken the physician's deposition. If they fail to do that, the judge is going to take the matter off calendar to allow them to revisit those options. This is a fun fact pattern. At the MSC, the employer asserted there was no substantial evidence that the applicant's medical information was false, inadequate, and had an inadequate history. The judge noted that the doctor didn't review records contradicting the history taken and needed a supplemental. This is not reversed. It's actually the judge was held up. It was found that the employee was on notice of the claim that the records were insubstantial and at their own peril, as a strategic policy, but in error, decided to proceed. Quote, a party is not entitled to assert she is prepared, ready for trial, and then be offered a second chance when it is determined that her evidence is not substantial evidence and not adequate to meet her burden of proof. So what are these situations where the defense actually wins on an evidentiary issue? I suspect in this case, faulty strategy or words to that effect were used successfully by the defense. Developing the record. So, medical opinions are deficient, inaccurate, incomplete. Here is how we handle this in order. The parties can obtain supplementals from the doctors who've reported, or if the supplementals don't do the trick, they can select a new doctor via 4060, 4061, 4662. If that's not an option, you should consider an AME, something, or the judge is going to ask you to consider an AME, something I would strongly recommend against. I think most of you have heard me get on my little soapbox and explain why I'm dead set against AMEs, not the least of which is they do the worst job in properly applying the AMA guides. Our rating department, our AMA guides analyses and rating department has actually done over 20,000 analyses now. And the statistics bear out very clearly that when you compare PTPs, QMEs, and AMEs and their ability or their success in properly applying the AMA guides, PTPs do the best job, QMEs get the second place, and AMEs do the absolute worst job in properly applying the AMA guides. So you wait around the longest for the AME report, you pay the most for it, and you're most likely to get the wrong answer. Interestingly, when I say the wrong answer, it's almost invariably the doctor is providing too much impairment, ergo too much permanent disability to the applicant in excess of what the AMA guides, when properly applied, would provide. So the judge will ask you to consider an AME. Hopefully, you'll strongly consider against going that way. The next alternative would be the judge to appoint a quote-unquote regular doctor. That's in the statute in the labor code now. It used to be independent medical examiner, but that IME, phraseology, has been replaced by regular physician. The definition is the same, so don't be thrown by that. Finally, the last option would be to develop the record after trial or submission of the case for the decision. Another fact pattern. Significant relevant sub rosa was served just prior to the MSD. The judge ordered development of the record before trial. And the question was, should this happen before trial or after trial, after the case is submitted for decision? And it was held, no. We're going to have the film reviewed by the doctors and the VR experts prior to trial. Why? The trial judge would be faced with the medical and vocational opinions greatly at odds with sub rosa evidence and no way to reconcile the two, absent of a reopening of the record. The delays of which applicant complains would only be exacerbated by such events. So in the name of speed and getting things done expeditiously, the argument was that this should be done before trial. And I think some of the other thought was once the sub rosa is provided to the experts, the doctors, the VR specialists, that this might change the party's position in settlement and help resolve the case informally. So what if the doctor is demonstrably biased? Reports not substantial evidence, and it's the position that there's no reasonable hope of correcting it via supplemental. At that point, a regular physician, an IME, is entirely appropriate. What's the extent of the development? Well, there's limitations. The judge is not to independently investigate the facts. The judge is the judge. The judge is not the defense attorney. The judge is not the applicant's attorney. It's for the applicant and defense attorney, to produce and seek and produce evidence. And this was demonstrated in a couple of cases. In this case, an IME was assigned, and the judge contacted the IME not once, but twice after the case was assigned to the IME to get further information. It was held that the judge was, in a technical term I learned at law school at UCLA, being very naughty. And that's because it violates the party's really right to due process, and that report with the IME, or that IME report, was thrown out. Similarly, the issue in this case had been that whether there were enough doctors willing to treat the applicant within the MPN. The employer provided a list of doctors to the judge, and the judge contacted 4 to determine availability for doctors of the MPN, that is. and based upon that survey by the judge, it was ruled that the doctors there were an insufficient number of doctors available, and the applicant was entitled to break out of the MPN. This on remand, this was remanded back to the judge with the instructions that he had done the wrong thing, because the judge can't conduct the investigation of facts. Once again, that's for the defense, that's for the applicant. They may conduct their discovery and let the judge know, for example, how many doctors they contacted and how many were available based on that survey. But that's not for the judge. That's not for the judge to be doing. Contrast that to the judge taking judicial notice of things. We talked about judicial notice I think the last time we talked about trial time subjects. Judicial notice is something that involves a lack of it. Well, that requires no evidence. The judge will take notice of something even if the parties don't offer evidence of that fact in. The sun rises in the east and sets in the west. The party can assert that. The judge will say, I will take judicial notice of that without any evidence. That's similarly, anything that on the DWC website, the Permanent Disability Rating Schedule, the regulations, the labor code, that the judge will take judicial notice of these things. Finally, in terms of the judge taking these investigations on their own, if the parties are present and the parties okay it, then that's not a problem. So, for example, in the situation where the judge started calling for physicians in the MPN, if the parties had conceded or agreed, acquiesced to this, and were present during the phone calls, that would not have been a problem. Fact pattern: the employee is nowhere to be found. Boy, this sounds like a Southern California case, probably LA, and definitely in 1997 this happened all the time. The judge ordered the parties to retain a private investigator. Now, does that make sense? So once again, we know that the judge is not supposed to conduct discovery, and if the parties, we also know if the parties agree to the judge's instructions in terms of discovery, that's okay. But in this case, there was a disagreement. One or both of the parties said, we don't want to do this, and the judge's order was rescinded. It was noted that he had no such authority to order the parties to retain a private investigator to conduct discovery for them. Evidence from other cases. What if you're dealing with a workers' compensation case and the applicant, for example, had a different case a few years ago, and there's a deposition transcript and some medical records, and you think that's reasonable or reasonably or relevant, rather. So you get that information, you want to submit it into evidence. That is not going to be allowed. And why would that not be allowed? Well, because the applicant's attorney or the applicant in this present case wasn't in all likelihood present at the prior case, therefore they were not able to cross-examine, assert their objections, et cetera, In short, it would be a denial of due process. That having been said, let's say there was a deposition of a doctor in the prior case that's relevant in the new case, and the party that wants to produce that deposition simply retakes that doctor's deposition and uses the older deposition transcript as an outline. That would give the opposing party the opportunity to attend, exercise their due process rights, and that should avoid that problem. Post-MSD evidence to rebut unanticipated testimony. That's one of the arguments that we're going to always make to try to get in sub rosa that was not identified at the time of the MSC. Fact pattern. Applicant testified about some forgotten body parts that hadn't been brought up previously. The defense offered a post-trial evidence regarding those body parts. The question was, well, this evidence that the defense brought together was after the hearing. Shouldn't that be precluded, or should that be admissible? And the answer was, oh heck yes, it should be admissible. It was the applicant that caused the need for this evidence at the time of trial. There would have been no need for this post-trial collection of evidence regarding the other body parts if the applicant hadn't provided this surprise testimony. So the only question in these kind of scenarios is Was it really surprise testimony? Is the applicant coming out of left field and testifying to something in contrast to their prior testimony and or their prior representations to the doctors? Or did the defense simply fall asleep at the wheel and ignore prior evidence that would have led reasonable minds to conclude that they might receive testimony that they now are claiming is actually surprise? All right. Admitted injury. Applicant testified at trial that they had no hand strength. The wife testified he got memory problems, problems with writing, unable to shower. Well, a lot of problems with that hand. Unable to watch the kids. How terribly convenient. Sub Rosa said that's a bunch of malarkey. And the question was the sub rosa, which had not been revealed at the time of MSC, was inadmissible, and it was held yes. The reason being that false testimony was surprise. It was unanticipated. The argument is, Your Honor, we believe that the applicant would not commit a fraud. We believe that the applicant, when he or she was sworn in, understood that it was their responsibility to tell the truth. Given the fact that we would not predict that this applicant, that this applicant would, given the fact that we could not anticipate that they would commit fraud, we did not reveal the sub rosa because the sub rosa is only relevant when the surprise, unanticipated, fraudulent testimony comes about. So in that situation, demonstrating the fraud, or demonstrating the surprise and unanticipated testimony, it was possible to get that sub rosa in. In short, the WCAB is going to balance the fairness of undue surprise versus the requirement, or balance the fairness of being able to respond to an undue surprise versus the need of the parties to collect and disclose their evidence by the time of the MSC. If the false testimony could have been expected, undisclosed impeachment evidence will likely be disallowed. Disclosing medical evidence at the MSC, the general rule, but it's only a general rule, is lose it. You'd rather list it or lose it. And if you're about to lose it, beg for forgiveness. We've got the labor code directly on point, 5502D33. Discovery shall close on the date of the MSC. Evidence not disclosed or obtained thereafter shall not be admissible unless the proponent of the evidence can demonstrate that it was not available or could not have been discovered by the exercise of due diligence, whatever that is. Once again, that's one of the make work phrases for attorneys. Could not have been discovered by the exercise of due diligence prior to the settlement of the conference. So, reports listed at the pretrial conference statement, but what if it doesn't exist yet? You know, the DOR has come on down and somebody has objected or not objected, but nevertheless there is an MSC and there's need to conclude there's a need to get another report. Is that going to be admissible? And the answer is yes, no, or maybe. So what do we have here? We've got a report. It's obtained post pretrial conference or post MSC. Is it going to be admissible? Yes, no, or maybe. Boy, doesn't that sound like an attorney response. Let's take the Levick case. Doctor was appointed. The doctor appointment was listed at MSC. The appointment occurred after the MSC because that was the earliest time possible for the doctor to see this applicant. The opposition, nevertheless, had time to obtain a rebuttal, so the judge held there was no prejudice, ergo this discovery should be allowed and the report obtained after the MSC should be allowed in. The District Court of Appeals said, nope. The ruling isn't just because there was no prejudice to the opposing party. That does not mean that the report, that subsequently obtained report is going to be admissible. Now, the best bet here is, I could imagine this case going the other way. The best bet is to, if you're facing this situation, is to argue that the evidence was unavailable and it couldn't have been obtained timely via due diligence. But you better provide evidence of efforts to conduct due diligence. Setting the doctor's report, doctor's examination earlier, prior to the DOR, for example. You certainly don't want to argue that I finally got around to it. After 3 years of discovery, I finally got around to scheduling the doctor's appointment right after I got the DOR. It gets confusing. Medical reports listed on the pretrial conference statement, but not completed by the MSC, it's not automatically inadmissible. It's not automatically admissible, but you don't want to press your luck. Let's imagine you've got a 2006 evaluation. So like suggested just a couple seconds ago, the MSC is 3 years later, and the report's still not admissible. Well, I think this is a situation that's going to anger the judge, and I think we could all foresee that this is going to be held inadmissible. There's no good cause for waiting 3 years. There's no showing of due diligence for 3 years. I mean, if the applicant were unconscious for 3 years, maybe, but this is 3 years and is an awful long wait. And also problematic was that the party didn't object to the DOR. You waive, if you do not timely object to the DOR when you still have further discovery to conduct, you've really set yourself behind the 8 ball and are probably have lost the day. IDing witnesses at MSC. Boy, this cartoon looks a lot like something I've seen down at the board. IDing witnesses at the MSC. Must identify your witnesses at the time of the MSC. It's not necessary to do so prior to the MSC, but by the time of the MSC, they must be identified. If you don't identify them, you will not get them on the stand. You will not have them sworn in, and you will not get their testimony unless you're able to demonstrate to the judge's happiness that the witness was completely unavailable, or due diligence. Again, that scary, confusing phrase wouldn't have worked in that case. So, true of injured worker, they must be listed or else. So if applicant's counsel doesn't list the injured worker, or they will not get the injured worker's testimony in. You must be specific in listing witnesses. Custodians of records and co-employees and supervisors, I've seen that verbiage used. Representative, employer representative, I've seen that verbiage used. Similarly, rebuttal witnesses, any other pertinent witnesses necessary to this case. These are all in quotations because these have all been used. Applicant supervisor, none of these are sufficient because they don't identify with particularity, sufficient particularity to put the opposing party on notice as to who's being referenced, who's being called as a witness. And this cannot be corrected at trial time. So if at MSC, the only witness that is listed is the employer representative, and then come trial time, the defense presents supervisor Mr. Smith, it's too late. This will not be corrected. Mr. Smith is not going to be sworn in and will not be allowed to give testimony. What are they going to say? So you or the other party has listed a witness. Let's say that applicant's counsel has listed a witness and you want to know what they're going to say. It's none of your business. In certain fact patterns, it's for an unhappy response or unhappy situation. In this case, there was a VR expert listed by name. There was a statement at the time of the MSC, that he would testify to LaBeouf. But I don't know about you, but LaBeouf is a word I always have to look at to be able to spell. There's way too many vowels in there. Anyway, he would testify as to LaBeouf, but there was no report put together. And it was admitted that his services were only obtained after the MSC. After the MSC, he interviewed the injured worker, but prepared no report that could be obtained or subpoenaed, or etc. The WCJ said, nope, this violates the employer's due process. They didn't have an opportunity to cross-examine the witness. The services were obtained after the MSC, not before the MSC. This violates the employer's due process. The WCAB and District Court of Appeals said, nope, the employer loses because the labor code only requires the name of the witness, nothing more. You don't need to disclose the contents of their proposed testimony. And given that disclosure isn't necessary, the later creation, by that I mean the creation of testimony after the MSC, is okay. I certainly am glad to hear that, because I see down at the board virtually every day parties or attorneys preparing their witnesses for testimony 15 minutes before the actual trial. If this case had held otherwise, there'd be a lot less action down at the WCAB district office. Now, they don't have to disclose the contents of the testimony, just have to identify the potential witness. However, no sandbagging is allowed. This is a phrase that the judges love to use. At MSC, the judge can order depos, make orders for the admission of evidence. Therefore, the employer should ask for a sandbagging remedy to obtain an opportunity to obtain a rebuttal, opportunity to depose, or to, and I love this phraseology, to exclude the witness's testimony as antithetical to the aim of fruitful settlement discussions. So here's how it really works down at the board. At let's say at the MSD, the injured worker reveals that they're going to have a diminished future earning capacity theory. They identify an expert by name, but offer no reports. It was held in this situation that discovery on the DFEC, the diminished future earning capacity, was not closed. The employer was still allowed to get their own expert, take the testimony of the applicant's expert witness. So this was a problem prior to 1113, but has not been much of a problem with VR expert testimony since 1113. Can you guess why? Okay, I can hear you all answering that question out loud. Well, per Labor Code Section 5703J, we no longer normally accept VR expert testimony down at the board. They're treated very much like doctors now, who you almost never see testifying down at the board. There has to be good cause to have a doctor or VR expert testifying. Their reports are preferred. Can I borrow that witness? Let's say you didn't identify the applicant as your witness, Joe Blow, but applicant's counsel did list Joe Blow as a witness. No worries, no worries. You can use any witness that's listed by applicant's counsel and vice versa. Fact pattern: applicant listed, or AA listed applicant. The employer listed 3 other witnesses, although not the applicant. At trial, applicant's counsel said, okay, you haven't listed my client. I've got a fact pattern. I've got all the records fine. I don't want you cross-examining my witness. So I'm just going to submit this case on the record and and I'm not going to offer any testimony. The employer tried to cross-examine the witness. The WCAB said, no, WCJ said, nope, you didn't list the injured worker, so you don't get to cross-examine him. And the District Court of Appeals said, absolutely wrong. The Labor Code says you can use one another's witnesses, which is kind of important. Oftentimes people think when they're down at the board at MSC that they just want to list as many witnesses as they can remember and sort of do their discovery later, determine who they want to call. But you risk, if you listed people that were not known by the opposition prior to MSC, if you list them, you may just whet their interest in investigating these folks and find out that they would actually provide testimony to your deficit. So, in other words, the upshot of that is be very selective in terms of who you're listing as witnesses at the time of the MSC. Make sure you have everybody covered that you need and that you want, but don't add any names that are unnecessary. Revealing sub rosa at the time of the MSC. We've already touched on this a little bit. It's a balancing act. You want to surprise the applicant when they start lying at trial? Of course you do. But you also want to avoid having the sub rosa stricken. And these are mutually exclusive exercises. Here's the general rule. If the sub rosa was available before the MSC and it wasn't disclosed at the MSC, we lose. It's not admitted. General rule number 2. Sub rosa was obtained after the MSC, and the employer fails to demonstrate why similar evidence could not have been obtained prior to the MSC, which is interesting. I found, I took the video of this guy post MSC. Well, you could have gotten it prior to the MSC. Well, could I? I don't know that the injured worker was conducting him or herself in the same way as seen in the film that we've obtained. Anyway, general rule number 2. Sub rosa was obtained after the MSC. The employer fails to demonstrate why similar evidence could not have been obtained prior to the MSC. In all likelihood, that sub rosa is not going to be admitted. Third general rule: the sub rosa is not disclosed at MSC. Something I like to do if I think I'm going to get away with it because I want to surprise the applicant. and the applicant engages in what we call unanticipated testimony. In most cases, this means lies. That in that situation, it's likely that the sub rosa will be allowed in. Here's the true rule. It's how ticked off the judge is and who made him or her more unhappy. Are we more unhappy with the defense for holding back on the sub rosa? Are we more ticked off at the applicant for clearly lying? The more clearly the applicant is lying to everybody as they testify, the more likely I think the judge is going to allow the sub rosa in. You do want to be specific when listing records at the time of the MSD, and you've got to identify them with specificity. All reports from Dr. X will not do the trick, or all records from Kaiser most certainly won't do the trick. This is not sufficient unless, of course, all the reports of Dr. X are what you want to introduce, or you really truly want to introduce all 12 volumes of the Kaiser records, most of which were bills and useless anyway. Why is this? Well, we've got a WCAB policy and procedure manual that speaks directly to this. Storage problems. Say we don't have room for all these files. I thought we were going paperless. I thought we'd have space for everything, but apparently still paperless is using an awful lot of paper. Due to storage problems, they want us to limit the number of records that we provide, limited solely to that is going to be used as evidence in the trial. Exercising due diligence, and the records are still not available as of the MSC. The Labor Code says that's not a problem, but they don't define due diligence. Again, yet one more phrase that is a make work words to keep attorneys busy. Get ready for a fight. There's going to be arguments as to whether due diligence was or was not exercised. So you want your records admitted. It's going to be your job to prove you engaged in due diligence. When a party appears at trial and asks the judge to permit introduction of evidence which was not disclosed at the time of the MSC, the party who's introducing the evidence must explain either why the evidence was not earlier available or why it could not have been discovered in the exercise of due diligence. Note the or. It's actually an and. This is what, although the case law says this, the way it's applied is to the contrary, or it's slightly different. Let's read this again, only clarified or corrected. The party must explain why the evidence was not earlier available and why it could not have been discovered in the exercise of due diligence. It's a twofer. So if you got trouble getting the evidence in, you knew of the defects in the reports as of the MSC, and you did nothing about it, the reports are going to be excluded. Here's a fact pattern. March 2016, there was a QME. 2 supplementals issued, no changed opinion. 7 months later, applicant's counsel files a DOR, and the defense objects saying, wait a minute, we want to take the QME's deposition. You know, that deposition, you know, that doctor we've got 1 supplemental from, 2 supplementals from, 3 reports from total. I've had this physician who we've had 7 months available to take their deposition. Well, now that the DOR has been filed, we want to take their deposition now. As you can tell probably from the tone in my voice, that was not well received, and it was held that it would not be taken off calendar to allow the deposition of the QME to proceed. What was the reason given? Well, we have an affirmative duty. We all know that. But we sometimes forget it. We have an affirmative duty to conduct discovery in a reasonable time, reasonably, expeditiously, economically. Just do it, do the right thing. Which reminds me, what's the best time to set an AME or QME's deposition? Now, I know normally the response is, well, when we get a report that we don't like, usually a PNS or MMI report, and let's say the doctor won't provide a supplemental report or won't provide a supplemental report that corrects what we think are in errors, well, then we set the doctor's deposition. I disagree with that plan of action. Actually, when I'm going to an AME, which almost never happens, maybe 1% of the time, or going to a QME, which is far more likely the case, I like to set the deposition at the same time I'm sending my letter to the doctor outlining my questions for them. You might say, why in the world would you set a doctor's deposition prior to the evaluation even occurring? And that's real simple. First off, remember, it's not expensive to set a deposition. It costs pennies. But what does setting the deposition prior to the examination do? One, it tells the doctor something. It says we think we know, we're knowledgeable about this topic, and feel comfortable enough. We'll feel comfortable if you go sideways on us. We'll feel comfortable attacking you in deposition. It also tells the doctor you just might want to play right and make it easy for everybody. The other advantage to setting the deposition, I'd say, well, wait a minute, what if the doctor does the right thing? What if you, say, shot the cannon over the bow of the doctor by setting their deposition? They don't want to go down that route, and they play well. Well, it's very cheap to cancel a deposition as well. Finally, let's say the shot over the bow is not successful. The doctor sends a report back that you find highly offensive. Well, by having set the doctor's deposition a month or two before, actually engaged in the exercise of scheduling it, we've now saved our time waiting around for the deposition date to come about. It's going to be, we're going to be able to do it much sooner after receipt of the doctor's report. So for a whole host of reasons, I think it's well worth your time considering setting the doctor's deposition before, even before the MMI evaluation. Successful efforts getting evidence in. In other words, how much due diligence is needed? Well, it must be reasonable. And I'll say this, I think this is the fifth time, a term that is a make work term for lawyers to fight about. And need to show you need not show that all possible discovery efforts were fully exhausted. Okay. So you want to get the evidence in, you got to show that you gave it the old reasonable college try, but if the opposing counsel says, well, you didn't try everything, that's not necessarily going to win the case for them. In fact, it's not going to win the case at all as long as we can show due diligence. Here's a fact pattern. Date of hire, 1999. Boy, that seems so long ago. Applicant testified that they had carpal tunnel 1 year after the date of hire, so 2000. At trial time, the witness testified, or the applicant testified, that the problems actually began in 2000 once again and got worse until they left for treatment in 2001. Post-trial, the employer, after the MSC, after the thing had been submitted for an FNA, the employer conducted a master trace, finding that the applicant actually began treating immediately after the 1999 date of hire, not an entire year later, which would seem very relevant, would strongly suggest that they'd had problems prior to the date of hire, and that there is, at the very least, a co-defendant that should be joined. Now, let's review this. That master trace was conducted after the MSC, after the trial. The question is this information going to be admissible, or is it inadmissible since it was not identified prior to MSC and introduced at trial time? In other words, did the defense make reasonable efforts to obtain it prior to the cutoff of discovery? Let's rephrase the issue. Can the record be reopened to allow evidence subsequently obtained contradicting the applicant's deposition and trial testimony? The answer is, oh, heck yes. Time to celebrate. The WCJ and the WCAB concluded due diligence was not shown because the employer failed to explain why the records could not have been discovered before the MSC. Okay, fine. But the employer pointed out that the medical discovery before the MSC was based on the applicant's deposition testimony. The applicant lied. Why should the applicant gain an advantage by lying? Well, the employer could have performed the master trace before the MSC And it might have been a better practice to routinely check all possible sources of information. It was reasonable to rely on the employee's deposition testimony and the appropriately discovered medical record, which appeared to be straightforward. So, in other words, when the applicant, it turns out the applicant lies, and we had no reason to believe that they were lying or guess that they were lying, even after trial time, we may be allowed to get subsequently obtained discovery in. No playing games. Let's say the report is disclosed at the MSD, but the report is not prepared because the applicant failed to appear at the time the evaluation was supposed to take place. It's going to be admissible. Once again, why should the applicant be rewarded for bad behavior for playing games? New problems need new approaches. Here's the applicant was deported to Mexico. Suddenly, I should add. So they testified via the telephone. The employer objected, saying, well, it's impossible for us to fully identify this injured worker and make sure that he is really who he claims he is. The wife was allowed to testify. It was held, even though she was not even listed on the MSC statement. Would that be allowed? It was held, yes. Why? Because the issue of the applicant's availability and inavailability and the need to testify over the phone wasn't raised until trial, because there's no way to know it was going to happen. So because the issue was not raised until trial, the need for testimony could not have been discovered via due diligence prior to the MSC. Cures are okay, new is not. What does that mean? There are lots of medical legal reporting requirements, signature, date, 139, whatever, attestation, etc. So that if there's a substantial substantive defect of the medical report as of the MSD, you can't cure it. You can't go back and say, Judge, I need to go back to the doctor and have this cured without showing good cause or good reason to be doing so, providing a good explanation why this hasn't been cured prior to the MSC. If, on the other hand, we're dealing with just a procedural defect as of the MSC, such as the thing was not properly signed, the report was not properly signed until after the MSC, or the 139.3 declaration was not signed until the MSC, here post-MSC cures are allowable. So, rule of thumb, substantive problems, not okay to cure them post-MSC. Procedural problems, not a problem. Why do you think this is? Why do you think we allow evidence in, or rather, why do you think it is that we allow the parties to cure procedural defects post-MSC, but not substantive defects post-MSC? It's real simple. The signature, the declaration, etc., are not evidence. They're not new evidence. And that's the whole point of cutting off discovery at MSC and identifying our exhibits, etc. It's all about the evidence, not about procedure. So why aren't the parties required to be fully prepared? I mean, that seems to be the question overriding this entire discussion. Oftentimes we find parties always have an excuse that explaining why they're not prepared. You would think, especially when they file the DOR or they fail to object to the DOR, they should be cut off from further discovery. And oftentimes they are, but not always. And I guess the only answer is it's the workers' compensation case. It's the workers' compensation in California. Get over it. Just because it doesn't seem fair, it doesn't mean we're necessarily going to be able to expect fairness all the time. On that happy note, we've not gone over. Normally I go over on these presentations, and today we've got a couple minutes under. So let me remind you that we've got another presentation prepared for next month. I'm going to have Tammy identify that. In the meantime, if you have any questions, comments, thoughts, insights, please send an email to Tammy. She will forward that to me, and I'll be happy to answer any questions you have. One last thought. We are constantly trying to come up with new and interesting topics to present each month. We don't know what's going to be particularly useful to you. So please send us some information. Please send them some ideas. If you could forward them to Tammy, and we'll be happy to take your suggestions under submission and in all likelihood create a PowerPoint and a webinar as per your request. Okay, hang on one second. Here comes Tammy. Have a wonderful day.